I was talking earlier this morning with somebody who'd been at the Conservative Party conference and was amazed by the upbeat tone of that conference, and and in contrast, the downbeat tone of the Labour conference, which of course is dogged by the reputation of Keir Starmer and the desire to ruin Britain's confidence in order to justify putting up taxes later, getting their excuses out by dumbing everything down. And it's extraordinary at a time when the gold reserves have increased in value to the point where it would be very easy to fund the two-child thing, to fund the pensioners' fuel allowance simply from the increase in value of gold over the last 6 months, and it's nonsensical. This ideology, which dominates either the Conservative Party or the Labour Party, gets in the way of real reality. And then we got on to asylum seekers, partly because of Robert Jenrick and Robert Jenrick's insistence. And Jenrick, as you may recall, was taken down significantly by Christian Guru-Murthy on Channel 4 when he tried to claim that under the 1951 Refugee Convention, the asylum seekers were not allowed to pass through France and then come to the UK because they were passing through a third safe country. And the difference in the UK government's policy on asylum seekers and the 1951 Refugee Convention, which Krishnan highlights, is significant because many people in the last Conservative government based their propaganda on the 1950 on claiming that this is what the 1951 Refugee Convention said, and it doesn't. And thanks very much to Krishnan for saying that. I mean, I think it's worth anticipating the usual smattering of people who will print the 1951 sections from the 1951 Refugee Convention under this video and tell me that I'm wrong. Let's just go through it. The 1951 Refugee Convention does not explicitly state that asylum seekers must claim asylum in the first safe country that they reach. It primarily emphasizes that refugees have the right to seek asylum wherever they want, and they should not be penalized for entering a country illegally if they are fleeing persecution in whatever form. And it obliges signatories to ensure that refugees are not returned to places where their lives or their freedom should be threatened, whether they are granted asylum or not. The focus on the first safe country is something that has gradually emerged through the 1990s, particularly in Britain. And recent UK government policy, still in effect because it hasn't been repealed, particularly advanced by figures like Robert Jenrick, pushes the idea that asylum seekers should apply for asylum in the first safe country that they arrive in, using this to justify measures like deportations to third countries like Rwanda. And the UK government has tightened the process of asylum by adopting stricter measures, arguing that those arriving by irregular routes, like crossing the English Channel, should have claimed asylum in a safe European country before reaching the UK. And this is the principle enshrined now in the Nationality and Borders Act, and the Rwanda Act and the Illegal Immigration Act. These three acts pushed forward by Suella Braverman, though she wasn't directly responsible for all three in the end because she'd resigned. The interpretation versus the convention is really the big debate, and this is where Krishnan Guru-Murthy and critics argue that the government's stance misinterprets the Refugee Convention, as it doesn't mandate that refugees must stop and seek asylum in the first safe country. Instead, it provides flexibility for refugees to seek protection in any signatory state. And the UK's government's policies have been called out as potentially undermining international obligations, while the government argues that it has managed migration effectively and legally. So it's managed migration legally by putting out its own laws that further define or compromise, depending on your point of view, the 1951 Refugee Convention. And because laws are based on words, it's how you understand those words. Now, there is an additional problem which quoting the 1951 Refugee Convention misses, because British law is also based on British case history. And the clash between these two groups reflects the tensions between strict national policies on immigration and international refugee protections that already exist. The UK's legal position regarding asylum seekers under Article 31C of the 1951 Refugee Convention, which prohibits penalties for illegal entry or presence, differs in significant ways from popular political rhetoric. So I'm going to break it down in a little bit more thoroughly. There is no obligation to claim asylum in the first safe country. Let me repeat that. There's no obligation to claim asylum in the first safe country, according to the 1951 Refugee Convention, which does not require refugees to claim asylum in the first safe country they reach. This means asylum seekers can lawfully move through multiple countries before claiming asylum in the UK. Politicians often argue that refugees must seek asylum in the first safe country, but this is not backed by the Convention. The UK follows Article 31 of the Convention, which prohibits refugees from penalties for illegal entry, providing they present themselves to the authorities without delay and show good cause for their entry. The UK, and this is defended actually by Suella Braverman's exchange with Tim Lawton on the 22nd of November 2022, I think it is, when she admits that if an anonymous refugee were to come from Africa, the only way that he could come from Africa to Britain would be via a small boat, and once he got to our shores, he should claim for asylum. The UK courts, notably R versus Uxbridge Magistrates Court in 1999, have held this principle, acknowledging that refugees may have valid reasons for not seeking asylum in, quote, the first safe country. More than that, a second ruling recognises that it is possible that up to 70 days can be spent negotiating for a refugee to negotiate his or her way through other, quote, seemingly safe countries. The Immigration and Asylum Act, Section 31, in Britain, says that refugees may be denied this protection if they pass through another safe country where they could reasonably have expected protection. This introduces a condition not strictly present in the 1951 Convention, but now part of UK law. And it is dependent on the Dublin regulation, which the UK was part of pre-Brexit, which allowed for the return of asylum seekers to the first EU country that they entered. But the UK is no longer part of this system post-Brexit. The UK has abandoned the Dublin regulation, therefore potentially compromised the Immigration and Asylum Act of 1999, Section 31. This has made the return of asylum seekers to other European countries much more complex. The UK's policy since Brexit has focused on refusing asylum seekers if the applicant has passed through a third safe country. However, Article 31 allows refugees a degree of choice, and the UK case law has recognised that refugees may have legitimate reasons for continuing their journey beyond the first safe country they arrive in, such as family ties or poor conditions in initial countries of refuge. So while many refugees do claim asylum in the first safe country they reach, a significant number move on to other countries like the UK for a variety of reasons, including family connections, language, or better prospects of protection and integration. But it's a very small percentage of the overall number of asylum seekers, and it's a very small percentage of our overall population. The UK's position under Article 31 allows for some flexibility, acknowledging that refugees may not always seek asylum in the first safe country. However, domestic law has introduced limitations, further limitations, particularly with regard to the inadmissibility rules and third safe country policies, which are now more restrictive than the international protections outlined in the Refugee Convention. The popular political argument that refugees must seek asylum in the first safe country is not supported by international law at all, although domestic legal frameworks have tried to enforce a stricter interpretation, and the propaganda, which no doubt will be repeated down below, suggests that it is implicit or explicit in the 1951 Refugee Convention. That propaganda is wrong.